Surrogacy bill and controversies. Surrogacy has become a big media issue recently, and there have been heated debates that have taken place in the media. It is especially following the proposed Surrogacy Regulation Bill 2016, which is in the draft stage. In this essay, we will understand the basic facts of surrogacy, its meaning, its social impact, its significance, and also the role of the government or the government's intervention. Now let us see what is surrogacy. Surrogacy is a method of reproduction whereby a woman, referred to as a surrogate, agrees to carry a pregnancy and gives birth to a substitute for the contracted party or the parties. Surrogacy may be natural, that is a traditional, or straight or gestational. Now let us see what is a natural or a traditional surrogacy. In traditional surrogacy, the surrogate is pregnant with her own biological child, but this child was conceived with the intention of relinquishing the child to be raised by others, such as the biological father and possibly his spouse or partner. And thus the child that results is basically genetically related to the surrogate mother. The child may be conceived via sexual intercourse, home artificial insemination using a fresh or frozen sperm, or it may be impregnated via intrauterine insemination or ICI, that is intracervical insemination, which are the methods performed in a fertility clinic. Then there are other categories of surrogacy as described earlier: the natural or traditional or the straight gestational surrogacy. There is a commercial surrogacy, and then there is a altruistic surrogacy. Now let us see the other categories of surrogacy, starting with gestational surrogacy. In gestational surrogacy, a surrogate is only a carrier or a female host, and she is not genetically or biologically related to the child. The surrogate is implanted with an embryo that is not her own, and she becomes pregnant with a child to which she is not the biological mother. After the birth, the surrogate relinquishes the child to the biological mother and or the father to raise the same. Then comes the commercial surrogacy. Commercial surrogacy is a form of surrogacy in which gestational carrier is paid to carry a child to maturity in her womb. This procedure is illegal in several countries, including in India. The commercial surrogacy is the process in which an individual or a couple pays a fee to a woman in exchange for her carrying and delivering a baby. At birth, the child is turned over to the individual or the couple. It can be either privately or through a legal adoption process. Then comes the altruistic surrogacy. Altruistic surrogacy is a situation where a surrogate receives no financial reward at all for her pregnancy or the relinquishment of the child. Although usually all expenses related to the pregnancy and the birth are paid by the intended parents, and such expenses could be medical expenses, maternity, clothing, accommodation, diet, and other related expenses. Now, there have been known instances of surrogacy in India, and they have been there since long time. Since then, the field of assisted reproductive technology, that is ART in short, has developed rapidly. But legally, the laws related to surrogacy are still in the nascent stage. At present, the agreement between the parties that are based on the ART, that is Assisted Reproduction Technology guidelines, are the guiding force. The codified law is yet to be adopted and implemented. With the recent growth in the intended parents opting for surrogacy here, India has become the much sought after surrogacy destination. However, all this same time, the nations all across the globe are condemning the commercial surrogacy because it results in a commercialization of a human reproductive system. and also it is susceptible to modification of children. Therefore, there are many various socio-ethical reasons. Therefore, surrogacy has become a topic of deep interest amongst the government of different nations and also among the medico-legal experts as well as at public at large. Now let us understand the rationale for surrogacy in a little more detail. The intended parents may enter into surrogacy arrangement because of many reasons. One of the main reasons is infertility. It could be female infertility or other medical issues which may make the pregnancy or the delivery a risky proposition. Another reason which is very pronounced is the risky pregnancy. That could be because the intended mother could also be fertile and healthy but prefer, because of the convenience or some medical issue of undergoing pregnancy and the labor that is involved for her. The risk would be pursued in this process. Therefore, because of this risk, the risky pregnancy issue is important. Therefore, the surrogacy is adopted. Furthermore, of recent phenomena is the same-sex couple surrogacy. This kind of surrogacy can help the same-sex couples who can realize their dream of having their own child, which is otherwise not possible because of their sexual preferences. And then there are single parents who would like to have a child of their own, and for them surrogacy is a boon for them to fulfill their desire of having a child without a partner, and surrogacy is definitely a ray of hope for them. Surrogacy is a multifaceted issue. It involves many individuals whose beliefs, expectations and interests are not always same or aligned. The primary individuals involved in this are the intended parents, surrogate mothers, fertility specialists, lawyers and surrogacy agencies. The basic surrogacy condition in India now is the child must be biologically related to either of the parents in order to opt for surrogacy in India. World over, the primary condition is that at least one of the intended parents must be biologically related. Now, commercial surrogacy has been legal in India since 2002 and it is coming under a critical examination these days. That is because India is emerging as a leader in international surrogacy and it is a sought after destination in surrogacy related fertility tourism. Indian surrogates have been increasingly popular with fertile couples in the industrialized nations or the Western nations. It is because of the relatively low cost that is involved in adopting the surrogacy method. Indian clinics are at the same time becoming very competitive, not just in pricing but in hiring the retention of Indian females as surrogates. These clinics charge parents roughly 1/3 of the price compared with the same cost and the procedure that is involved in nations like United Kingdom. In 2008, the Supreme Court of India, in the case of Manji, that is a Japanese baby which became famous in the media, held that the commercial surrogacy is permitted in India. But it also gave a direction to the legislature to pass an appropriate law governing surrogacy in India. At present, the surrogacy contract between the parties and the assisted reproductive technique, that is ART, clinics guidelines are guiding force. Giving due regard to the Apex Court decision, the legislature enacted what is called ART Bill, that is Assisted Reproductive Technique Bill of 2008, and it is still pending and it is expected to come into force somewhere in the next coming year. The Law Commission of India also examined this and it has specifically reviewed the surrogacy law, keeping in mind that India is an international surrogacy destination. International surrogacy involves bilateral issues, as said before, where the laws of both the nations have to be at par or uniformity. It is because it involves the commercialization of the human reproductive system, it involves the exploitation of women, it involves the commodification of children born out of surrogacy as well. Therefore, in this context, the Law Commission of India submitted a report. Based on the report, government proposed a draft bill, and these are the following key points of the proposed draft Surrogacy Regulation Bill of 2016. Now, the Surrogacy Regulation Bill of 2016 proposes to regulate surrogacy in India by establishing a national surrogacy board at the central level and also at the state level called state surrogacy boards, and appropriate authorities as are necessary for this setup in the state and union territories. The proposed legislation also ensures effective regulation of surrogacy, prohibition of commercial surrogacy, but also allow ethical surrogacy to the needy infertile couple, and it is for the Indian couples. The major objectives of the bill are to regulate services in the country to provide altruistic ethical surrogacy to the needy infertile Indian couples, and it would also like to prohibit commercial surrogacy including sale and purchase of human embryo and gametes to prevent commercialization of surrogacy and to prevent potential exploitation of surrogate mothers and protect the rights of children born through surrogacy. Therefore, it has a multiple objectives. Now let us summarize the salient features of the bill point by point. The bill proposes to allow altruistic ethical surrogacy to intending infertile couple between the age of 23 to 50 years and 26 to 55 years. These age limits are for the females and males respectively. The intending couples should be legally married at least for 5 years, and they should be necessarily Indian citizens. The intending couples should not have had any surviving child biologically or through adoption process, or also through surrogacy earlier, except when they had a child who is mentally or physically challenged, or this child suffers from a life-threatening disorder with no possibility of permanent cure. The intending couple shall not abandon the child born out of a surrogacy procedure under any condition. The next, the child born through surrogacy will have the same rights as are available for the biological child. Further, the surrogate mother should be a close relative of the intending couple, and she should be between the age of 25 to 35 years. She can act as a surrogate mother only once. The surrogate mother will carry a child which is genetically related to the intending couple. Further, an order concerning the parentage and the custody of the child to be born through surrogacy will have to be passed by the court of the magistrate of the first class. Further, no person or organization, surrogacy clinic or a laboratory or a clinical establishment of any kind shall undertake a commercial surrogacy. There will be an insurance coverage of reasonable and adequate amount that shall be ensured in the favor of surrogate mother. This takes care of the welfare of the surrogate mother. Further, no person or organization or the surrogacy clinic or the laboratory or the clinical establishment of any kind shall undertake commercial surrogacy or abandon the child or exploit the surrogate mother and sell a human embryo or import an embryo for the purpose of surrogacy. Now, violation to this law's provisions shall be an offence which are punishable with the imprisonment for a term which shall not be less than 10 years, and it will also carry a fine which may extend to 10 lakh rupees. Now, let us again summarize the basic provisions of the law in a common terms. Number 1, the surrogacy will not be allowed for a homosexual couples, single parents, couples in live-in relationships, the foreigners, and also couples with the children. And as regards commercial surrogacy, couple must be married for at least 5 years. Either one of the couples must have a proven infertility. Only Indian citizens and NRIs are not included in this category. That means the foreigners are not allowed to be included in the commercial surrogacy. The age of the couple will have to be 23 to 50 years for females and 26 to 55 for males. Now, women can be surrogates only once, and married couple can only have one surrogate child. The couple should employ an altruistic relative, that is, a surrogate mother should be a relative who is sympathetic to the situation. And finally, the egg donation is banned in surrogacy bill, proposed draft bill of the surrogacy. Now let us critically analyze the positive and negative points of the bill as viewed by the public at large. The proposed bill insists on a necessity of only a relative being a surrogate mother. Therefore, there has been a criticism that because of this provision, the bill limits the possibility of surrogacy to a very large extent. The idea of altruistic surrogacy, where a surrogate receives no financial reward for her pregnancy or the relinquishment of the child that is expressed in the bill, greatly limits both potential surrogate mothers as well as couples wanting children. The question has been raised: if a woman willingly consents to being a surrogate mother and is assisted of a safe delivery and the baby is also assured of a safe home, why she should be limited to only one surrogacy? After the surrogacy industry has boomed, a lot of women were dependent on the same. There was a commercial aspect involved, of course. The issue here seems to be that a woman is exploited for her body, and this too is a legitimate issue. But it has been argued that just as in the case of a sex worker, if she is consenting and is being paid proper amount, then this should not be an issue at all. In certain European countries, sex work itself is fully regulated and sex workers have a full constitutional rights. And this issue is very different from agreeing to go into a sex work for lack of any other options. Similarly, the surrogacy law should be set out in such a way that there is a full consent of the woman in question. And if the consent of the woman is obtained, why there should be such a prohibitive law against surrogacy? Here, instead of regulating the ways and the policies in which women's exploitation is prevented, the bill has eliminated the idea in its totality. One of the most contentious points of the bill is its blatant ban on surrogacy rights of homosexual couples. This issue has been considered as a huge denial of justice to the gay and lesbian community at large. However, the bill is extremely necessary in certain places in India, for example Gujarat, where baby farms exist. That is, underprivileged women are rounded up in scores and they are given out as surrogates to potential parents. In this industry, middlemen play a large role. That is an accepted fact. Therefore, they take a huge slices of the amounts that are paid by the parents, and only about 25% ends up with the actual surrogate mothers. Therefore, these surrogate mothers are definitely exploited. And now, although the bill will greatly benefit these women, where will they go for wages now? Otherwise. So, therefore, there has been a criticism that the bill does seem to do more harm than good. It is because it exhibits a general policy of a state banning altogether or censoring an activity which is almost completely, and instead it should have looked at the ways to use laws to regulate and improve the situation. It has been suggested that the laws need to be relooked so that they actually benefit surrogate mothers, prospective parents, and also the children born from surrogacy. It has been generally argued that the bill exhibits a lack of understanding of agency which ought to be given to a woman, and that a woman should be able to make decisions when the question is with regard to her body. Therefore, there is no need for the state to be a big brother in the surrogacy matter.